Cool. Judge, I'm on case 5612.
All right.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment?
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Miss Gallett here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Miss Gallett has, first of all, now she has a phone number, a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take, as well as hormones. So all of that kind of, well, it can, no, I don't want, let me word this correctly. All of that is helping reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has two different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon housing if she were to be released. So all of that combined, her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear. She has no intent, and there is nothing else holding her. I believe she has a 15th district court case, but she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th district court case, which is just a Parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day. So
between March 20th and that time, what was she doing?
She was unmedicated. Her husband also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College, wants to do linguistics, just wants to start becoming better. And her meds was the first step to that, Your Honor.
Mr. Killowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault matter in Eddie Hospital. I understand that things have happened in the psychiatric environment there, but that is just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround in a very short amount of time. I don't know if Mr. Lucia has anything else to provide proofs of some of the housing. Miss Gallett is apparently a native of the California area, doesn't really have any ties to our county either. So I'm not sure. I'm not sure that we'll see her, quite frankly. If we do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me you asked.
No, I didn't.
Although you don't need it. So, that's it.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you.
And on behalf of the people, Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Adamson, who's approaching. Could you state your name for the court?
Noah Adamson. Thank you.
Your Honor, we are respectfully requesting an exam be set in this matter. The only outstanding...
All discovery, go ahead.
No, I'm sorry. A 911 call has already been requested and should be here either today or tomorrow.
That's correct, Your Honor. And if we could address it on the phone.
Preliminary examination in this matter will be set July 22nd, 2025, 9 a.m. That will be before Judge Barr. as to bond.
Your Honor, it's come to my attention that since arraignment, the defendant has made 37 calls to the victim in this case, and at this time we would be asking that his phone privileges be revoked.
Where'd you go? Oh, no. Response.
Your Honor, unfortunately, we don't have, the calls. We don't have the timings. I can't really respond without having the information underlying the argument. Mr. Adamson actually wanted me to make a bond argument today for his release, as this is the only case holding him, and he has to go back to work. He has a separate residence from the alleged victim. I will have a conversation with him about ensuring that he understands and will comply with the no contact order. I know he's been contacting his family and friends using the phone here, as he has a lot of kind of business to attend to on the outside, and his rent's coming up and all that. So I would ask for the court to reserve judgment until the exam date in terms of his phone privileges.
These are to the victim's number.
Your Honor, I believe so. Yes.
They are. So, Ms. Yagi, are you making a motion to reduce his bond? I mean, was that what I was hearing or not?
I am, yes.
Go ahead, response.
I would object, given the phone calls. I believe the defendant is also currently on probation for a previous conviction in circuit court for a GBH DV added the same victim that he was sentenced on, I believe, in February of this year. In this case, they had an argument. He grabbed her by the wrist, pushed her up against the wall. She was able to free herself, tried to use her roommate's phone to call 911. He takes the phone, hangs it up. She then tries to call 911 from another phone. He then takes that phone, hangs it up, and he entered the apartment to begin with without permission. I have concerns given that he is on height of probation for a DV offense with the same victim from this year and is engaging in that same behavior. Would ask that bond reduce.
Anything else?
I just want to note that that there's no hold for that case, and we discussed the tether. He's in accountable choices. He's in contact with his probation officer and hasn't been violated yet. So, but nothing further, Your Honor.
Defendant's motion for bond reduction is denied. As to people's requests as to the revoking of his phone privileges, this time the court will revoke the defendant's phone privileges. Defense is entitled to and can request a hearing on that matter once they do the calls.
Thank you, Your Honor.
Mr. Kelly, please state your name for the record.
Brandon Isaac Kelly.
Thank you.
Your Honor, today we are asking for an adjournment to continue a plea discussion and allow me to do an AIM referral. I am also asking to address bond.
Probable cause conference will be adjourned July 22nd, 2025. 9 a.m. bond. Go ahead.
Thank you, Your Honor. Regarding bond, his bond is currently a 5,010%. We're asking you to consider a personal bond. Mr. Kelly does stay in Washtenaw County. He has an Ann Arbor mailing address. He reports that prior to being in custody, he was engaged in community service. He does not have a criminal history. He understands the bond conditions not to go back to target or have contact with the complaining witness. He does have another case open, but it is my understanding, based on the record on JIS, that $100 bond will turn into a personal bond upon his release on this case.
So he's held on another matter.
Yes, but if this were turned into a personal bond, that would automatically turn into a personal bond.
Is that the way the bond reads?
On GIS, it does state that Magistrate Garwood said it that way.
People believe that the bond term that is very fair and appropriate in certain cases that other unprovoked assault. Most of the cases that has consist of him being in public places and just punching people in the face, either because they looked at him or he looked at them. In this particular case, he had the use of the watch as a makeshift brass knuckles, which escalated into a felony. These cases happened within about 3 weeks of each other in the month of June. I'm not really sure what's going on with Mr. Kelly, but I'm trying to not the most stable at this point. And I would request. that-
So was he on bond on the other case when this
Not yet.
happened? Not yet. All right. Anything else?
No, thank you. Oh,
Court
sorry.
does believe that the bond is set appropriately. Motion for bond reduction is denied. Bond will continue. Thank you.